concerns of the Act, but as a parliamentarian, the Act has passed through the Parliament. And there was one time when a former Prime Minister, my leader, Patrick Manning, had said at the time that if the law is not perfect as we create it, then we should proceed to put it in place as perfect as we think we can get it. And if at a later stage it has to be corrected, amended, redirected or so, then that would be the evolution of the law. But the intention of the law is what is important here. And as a new government in 2015, we started off on that course to try to make this law as operational as possible. I must also say that a lot of the conversation that surrounded the proclamation of this law came from people who either were not involved, not read the law, completely unaware, and even some of those who were involved, I think they were misunderstanding a significant part of the import of the law. Because when we proclaimed it in full recently, I did see in the media some disturbing comments from people who I thought were in the know, saying as to what the coming of the law means, what this will do and what that will do and what the other will do. And some of those expectations are not in the law. And therefore I expect that there will be some serious disappointment in some quarters, because the procurement regulator is really a monitor of operations which will take place elsewhere. The regulator and his department will not be awarding contracts and will not be adjudicating on contracts unless there are complaints of issues with contracts. So I was a little disappointed at the conversations that were taking place where this law was being supported as some panacea, bringing an end to corruption all over here, there, and everywhere else, because the regulator is now in place and so on. Nothing is further from the truth. And the most important thing that we had to do was to make sure that the public service understands what the law requires of each department or each person acting in a department as a procurement officer. Because what the law has done, which was not there before, is to designate persons who are at this time known or unknown, designate them as procurement officers in their departments. Those persons will emerge and will become known to the public as they get these designations. It doesn't even say what the qualification of a procurement officer is supposed to be. And it also does not say what level procurement should be done at. These things are going to emerge in the operationalization of departments. So the government's consultant came in this morning with the Minister of Finance and gave explanations and presentations to the full public service. And for a couple of hours, we fielded questions from the PSs, some of whom came requiring clarification or expressing concerns of one kind or another. So we did have some fruitful discussion. And what came out of this morning's discussion is that this exercise will have to go on again in other areas with other people for quite some time. So today we had the permanent secretaries and the ministers. I've already asked the Minister of Local Government to do the same thing with local government practitioners in local government. I've asked the Minister of Finance as corporation sole, responsible for the state enterprise sector, to do the same thing there. And I'm also going to provide the resources and ask the Tobago House of Assembly to do that in Tobago with the Tobago House of Assembly. So if we cover the cabinet, local government, Ministry of Finance, Corporation, Sole, State Enterprises, and the Tobago House of Assembly, that would cover largely the government's administrative umbrella. And it will take some time, because if you were in the meeting this morning, you would feel the, I wouldn't say trepidation, you would feel the uncertainty that some officers have with respect to what their role and responsibilities are, and more so when there's some penalty to be ascribed personally to the procurement officer for shortcomings in the procurement of a department or an agency. So people are needed to be comforted that the operations can take place without them being unduly exposed to unreasonable attack or even lawsuits for that matter. So this process will be underway, and I'm going to ask all public servants to cooperate as they are invited to be educated in the various components of this very broad law. Because as you would know, members of the media, procurement takes place across the entire spectrum of the state. Some involving small items, some involving large items, some involving small sums of money, some involving large sums of money. The law does not differentiate. It now requires certain processes and procedures to take place, and it behoves all persons involved in managing government's affairs and distributing or managing government's assets in terms of contracting to become familiar with the law. That is a requirement now. And procurement officers, as they are designated, they, more than others, would require to understand the law. And unfortunately, I can't tell them to rely on what they've read in the media, because I have seen a lot of misrepresentation of this matter in the media. But I'm trusting that the media, in these exercises that we are, the next one that the Ministry of Finance will do, which is sometime very soon, I'm sorry that today we could have invited the media in today, and that would have helped. But next time, and I'll ask them going forward, just to make sure the media gets it right along the way, and you too get some of your concerns clarified, because it's a very complex law, you know, and you need to, it's going to take some time for the correct version to prevail, you know, across broad circles. You see, because we've had amendments to the Parliament in 2015, 2016, 2017, all the way up to 2022. And these amendments had to do with the regulations that came to place in the beginning and the end. Because there were three areas that I think that dominated the conversation. No, is it four? There were 4 areas. One was the whole question of the freedom and the right to choose medical services of your choice and not have it dictated to you by any process which could turn up somebody who you don't think is the best doctor or the best medical service. The same thing to do with legal services, where you can't simply go by the price the lawyer is going to charge to get a lawyer to defend the state. Because as you know, litigation in Trinidad and Tobago is furious and fast. Some of them look like small items, but they have serious far-reaching import and consequences for the state and the taxpayer. So every time a man of straw is used by some person to challenge the state on a matter, the state has to put its best defense forward, because to lose the matter for want of quality advocacy is to end up in a very, very difficult situation as the taxpayer, because the state's financial burden is always on the back of the taxpayer. So the state, going forward, has to get competent, experienced advocates at all stages in virtually every event. And that is something that the state will have to be satisfied that in the individual matter, on an ongoing basis, on a case-by-case basis, that you are having the required competence and the advocate of your choice. So that caused us to have made an amendment to give the state the right and the freedom to do that. And the third one was government-to-government arrangements. One such example was our use of the Australian government to obtain those ferries that we did and the Coast Guard vessels. That is not a matter for a public servant. That has to be a decision of the administrative directorate of the country to do that. And we believe, I don't expect everybody to agree, but we believe that such an intervention by the government or any government is required if the government is to play its role as the premier decision maker on behalf of the wider citizenry. The government must be able to have freedom to deal with other sovereigns on matters which the government determines requires the government's intervention. And of course, the whole question of borrowing, the Ministry of Finance will have to determine how borrowings are done in dealing with the public and other debt. This is a matter for the Ministry of Finance, and of course, while there are guidelines and strict regulations, the freedom to get the best deal for the country in financing is something that... So those are the 4 areas that amendments were made. And I've seen in response to that, persons who I suspect have not even read the law and paid no attention to the parliamentary debates speak about the bill being gutted. In fact, one of the amendments we made was when the regulator himself pointed out the existing law had required that the regulator dispose of property. And he had to point out to us, and it was amended, that you can't be regulator and disposer at the same time. You're either fish or fowl. And we had to make an amendment where the actual disposing of state property is not being done by the regulator. And that was one suggestion that came from the regulator. And of course, we were pilloried for interfering with the law as first passed. So the law did have some requirements to be shaped to where it is today. And I think we're in a much better place, although it is not, for me, and I'm speaking here as a parliamentarian and as Prime Minister, and we are not at the most comfortable place. We now have to move with some evolution and understanding of this law to get the best out of it. Because we have, in 2022, there were a series of regulations under certain subheads, which are the skeletal parts of the law, which had to be fleshed out by the regulations. And that was the challenge proceedings. How people will make challenges when they believe something would have gone wrong. That is a major part of that the law covers. Another regulation covers the evaluation. If you are going to make selections of people getting government contracts and government services and so on, how is the evaluation done and who is doing it and at what stage and so on. And then we have the ineligibility proceedings. Who is ineligible to participate in the proceedings and receive the selection of those who are selecting. Then we have the miscellaneous regulations for miscellaneous items. Then we have participation in procurement. How you participate, what is in place to allow you to participate transparently and with accountability and integrity. Then you have the pre-qualification and pre-selection, because many of the larger contracts have a requirement for you to be qualified to be able to tender. Because you don't go out and ask somebody who's selling orange on the pavement to build a hospital. The entity has to have some capacity and capability and even experience and even certain financial support to be able to accept your contract. So there's pre-qualification, and once you pre-qualify, then what are your terms? And your terms are put out in the bid process. So the law caters for pre-qualification and pre-selection. Then, of course, the procurement methods and procedures. These are very, very details that can create all kinds of cantankerous outcomes. A contract has been awarded, A says B shouldn't get it, C says D shouldn't be involved, other one said I did. Oh, a lot of contention could flow if the law is not properly understood here, and followed and applied. Then we have the procurement of consultants. It is in this area that we extracted the consultants in health, in law, and of course, in finance. So it does make reference to other consulting for other purposes, but those specific areas, we had removed those areas because we believe that the procurer should have the freedom to have the trust that they're getting the best as per their own judgment. And of course, the record of proceedings. If there's no record of proceedings, then all fall down. How did this come about? Where did it start? What does the record say at this stage or the other stage? That is how you will determine if there was wrongdoing, if there was bias, if there was corruption, and so on. That's it. And of course, you have the retention and disposal of personal property. So these are all areas covered by the law, and as you would have seen over the years, it evolved from an original act that was passed, deemed to be a panacea for all the problems that arise around government contracts and so on. But then we had to work with the lawyers for a number of months to proceed to a point where we could have taken the chance to proclaim the whole law with all its parts, maybe with 1 or 2 flaws, maybe with 1 or 2 warts, but now we are going to operationalize it. The law is now in force, but we are required to work with those who will carry out the law, and I'm sure that from time to time, very soon, you, the media, will start reporting on the outcomes of the proceedings and the interpretations of this law. So we have now put that to bed at the level of the cabinet and the government. It's now in the public domain, and we have to make it work. The other thing I want to touch on this afternoon is the whole question of the role of the Office of Prime Minister in the advising of the President's office as to who in the legal profession would be elevated to the status of silk, meaning senior counsel. It used to be Queen's Counsel when we had a queen. And since we don't have queen and now we have a king, if we were still a colonial country, subject, if we were still colonial subjects, but we set about to have senior counsel, meaning counsels who are described in a particular way. Not that you are the counsel to the king or to the court of St. James. Let me tell you, again, I'm sure you would have heard this before, I think today, I need, given that it was my signature under which it went out of the cabinet to the president, I need to tell you this process of selecting group or groups of lawyers to carry that station of senior counsel dates back, well it was Queen's Counsel then, and as the Attorney General pointed out, 1964. This is a copy of the advertisement, 1964, and you would see there the signature of the Attorney General, G.A. Richards. And of course, if I show you this one, same thing, and you would see the Ramesh Miraj, and this was 1997. And of course, you would have carried the one that carries the signature of A.G. Amor. What is it? How does one get considered? It's like, it's like picking a West Indies team. Most people who could hold a bat and made more than duck feel they should be on the team. That's normal. But these are the parameters. A, professional eminence and distinction which establish them as leaders of the profession. Sound intellectual ability, that's B, and a thorough, comprehensive, and up-to-date knowledge and practice in the fields in which they practice. C, outstanding ability as an advocate in the higher courts. D, the highest professional standing, having gained the respect of the bench and the profession in observing the advocate's duty to the court and to the administration of justice while presenting their client's case, and being formidable, fair, and honorable as an opponent. E, total professional integrity. F, maturity of judgment and balance. And G, a high quality practice with at least 10 years experience, and you would have done many or some demanding cases. Those are the yardsticks under which you would look at the applicants, because you invite people to indicate an interest in being designated senior counsel. And when they respond, and on this occasion, of the hundreds of, maybe thousands of lawyers we have, thousands of lawyers, many of them young people, We had 57 people applying, saying that they think that they should be selected. But nothing wrong with that. The process asked for those invitations. And then, in carrying out my oath of office, which I keep reminding you of, while I hold this position of Prime Minister, I am constantly cognizant of the oath that I took, which says that I will act without fear, without favor, without malice, and without ill will. That is a requirement taken under oath by the Prime Minister of Trinidad and Tobago. I took that oath. So when I go to hold discussions or consultations on this matter, it's in that context where I would want to know where the individuals stand in their profession, not who their family is, not who they're married to, not who is a cousin, uncle, brother. What is their standing? And that's number one. And of course, I told you about other considerations that are required, not the least of which is total professional integrity. So when professional integrity is one of the requirements, that will explain why we had a problem when our sitting Prime Minister could recommend himself, I presume, if this process was used, recommend yourself to the President and say, me, leaving hundreds outside, as they are left out now, and then come and talk now about attacking the President because the President's husband, who I have not heard a single comment negative about his professional capacity or record. And the same thing goes for everybody else of the 17, of the 18 people who were selected. If there are questions about my decision, about the people's professional capacity, integrity, or capabilities, then I think those are valid. But if you're talking about it on the basis as to who, I will simply say this evening, familial connection was not a consideration. It was item number one, your standing professional eminence and distinction with respect to being a leader in your profession, and the other 6 categories. That's what it was. And one of them is the individual integrity. So himself telling himself to tell the President that I want to be senior counsel. I think I read in this document that that ain't so good. And himself telling himself that he wants to be senior counsel. And herself tell himself, I will tell the President about yourself. And senior counsel is conferred. That is not how it is on this occasion. As a matter of fact, on this occasion, which is not the first time I see it being said in certain releases where they like to release, I see it being said Thank you. Sorry about that interruption. I see it being said that this is the first time I have stepped out for some nefarious reason to appoint senior counsel. And of course the implying is because that has become somebody's beef. I have now come out to appoint senior counsels. I will tell you that is not correct at all. I seem to recall at an earlier time in my term as Prime Minister, in 2018, I was Prime Minister for almost 3 years when I made the first recommendation to the then President to appoint some people as senior counsel. Since then, 5 years has elapsed, and it has come up again in my duty to do the same thing. And especially since we were clearly short of the number of senior counsels. You see the outcome of that. One of the outcome of that is that because we had so few senior counsels, and a requirement for litigants, both the state and others, especially the state, to get to court so frequently, it means that all these jobs were going to few people. So now when you hear herself tell herself to give herself talking about the fees being paid, and we have made additional senior counsel, the effect that that will have is to not let just a handful, like 3 or 4, be the recipient of this steady stream of briefs that the state must respond to. On no occasion, when the state has legal business, can the government and its agents take the position, I'm not responding, I'm not coming to court, I'm not going to fight the matter in court. You're summoned to court. The government is, in fact, in some instances, the target for litigation. Those millions you're hearing there, making it sound as though it's something out of the ordinary. Let me remind you how they are paid and for what reasons. Every time a man of straw is encouraged to take the government to court on all kinds of concerns that certain people have, read millions in that, because the state has to go to court with proper legal standing and advocacy to prevent the man of straw from getting a decision against the state on a matter that is sometimes at the root of our constitution. So we see that, and if the man of straw loses, he has a cent to pay. But if the state loses, the lawyers have millions to collect. I've heard one former minister of government in the opposition saying that there's a legal cartel in the AG office. No, sir. Public service wouldn't allow that. There might be a legal cartel in their office because the men of straw representing them coming out on all kinds of matters, including, if my memory serves me right, 65 lawsuits during the pandemic, suing the nurses, the doctors, the prime minister, the attorney general, the minister, in the middle of a pandemic. We are the only country in the world where I know this has happened. We have to be fighting in the hospital, fighting in the health center, and fighting in the court while COVID raging. And every single one of those lawsuits require expensive lawyers going to court, because you all know, if you ever had anything to do with lawyers and the court, that legal support is not cheap. As Carl Hudson Phillips said, you pay peanuts, you get monkeys. The state cannot go to court with monkeys. You have to go with the best lawyers available, because if the state loses some of these cases, every time a murderer is convicted and he appeals, and that goes to the Privy Council, at every step of the proceedings, from the arrest to the Privy Council's visit, the first and the second, that comes up being paid for by the Office of the Attorney General. The one thing I could tell you, the concern in this government is not one of paying the fees, because that is a given. The state has to pay its legal fees, and I hope that those fees are reasonable. But the one thing that we're not having to fight with this government is that the fees are not ending up in the pockets of the Attorney General and his associates. That much I could tell you. And I could tell you something else too. In the 57, you don't want to know who applied for senior counsel. I want to know, because it's my job to know. So, ladies and gentlemen, as I had to do this job, I approached it in the following way. You would have seen a large number of people. The last time I did this, I think it was about 3 people in 2018. And then the next time around, it was 18 people. There's no fixed number, big number, small number. But on this occasion, I looked at the various components, because in the intervening years, you'd have been talking in discussions with professional people, and they give you certain, you improve your ability to appreciate the profession, if that is possible. And we have, let's take the category of commercial law. And you look to see, in the area of commercial law, who are the leading lights, who have applied, and who stand in position. So most people are there. Commercial and public law. Some of those same people would qualify under commercial and public law. Then you have industrial relations law. And those three categories tend to have the same kind of people in there because they're similar, but some people are specialists in there. So you would look at, if you look, when you find out who they are, you will find out that that area was well served by a certain number of people who have been elevated to that status. Then, of course, we have family law. That family law has evolved as a major component of our jurisprudence in Trinidad and Tobago, of our family court, and some people specialize in that. And for everybody, the issue you have is the major issue. If your requirement for legal support is family business, that is the major thing in law. So you see people from family law being elevated. You would see legal drafting, something that may not have been considered. But a major support for the system is the rate and quality of the legal drafting that goes to the parliament. And if a person for decades had been there and is in fact the expert in there, comparing with colleagues, you see that taken care of. Intellectual property, that's another major area of growth in the legal profession service. You would see that. Criminal law, of course, everybody knows about that. And by criminal law, I don't mean, I mean that division of lawyers that deal with the criminal matters. And I don't want to end up like my colleague and say that I'm talking about criminal lawyers. I'm talking about the lawyers that practice in the criminal court. And you will see a number of persons, either in the state or in the private sector, who specialize in that area. And of course, there are some persons who work behind closed doors, but they are major contributors to certain aspect of the delivery of services, and you see that. So the whole spectrum of the practice as subdivided in those areas was covered, and that would give you an idea as to how and why we ended up with the number we did. So ladies and gentlemen, I want to ask the public to disregard the misinformation that is meant to create discord and to cast aspersion. Because, you know, I have some parliamentary colleagues who set about to do that deliberately. How else can you explain senior counsel, self-accomplished, and senior counsel almost accomplished, leading the charge, saying that the president is to be pilloried for nepotism and conflict of interest because her family members were considered and found to be acceptable on the basis of their professional standing. What exactly are these MPs asking the president to do other than to break the law? That's what they're asking the president to do. Because under the Constitution, the Prime Minister, in keeping with his oath of office, does his job, and the job ends with him advising the president to sign their certificates. If the president takes advice from these jokers and refuses to do that, the president will be in breach of the Constitution. That is what they're going on platform and calling press conference, inviting the president to do, and knowing full well that the president has nothing to do with who is selected. Why then are they telling our children that the president ought to be pilloried for doing something wrong, and you in the press writing editorials talking about what? About a latitude which doesn't exist. In the Constitution, there are situations that say cabinet, but in the Interpretation Act, cabinet there means says president. It means the cabinet. A decision from the cabinet goes to the president, and the president carries out that decision. You may recall in 1995, I think it was, when Basdio Pandey was Prime Minister. There was a case where there was an election. I think it was 2000. It was 2000. There were so many elections around it. It was 2000. Prime Minister Pandey appointed some members to his cabinet, people who had contested the election, got votes, but didn't get enough votes to win. And on that occasion, for the first time in our country, a prime minister, with the support of his party and supporters, appointed those people. The law did not prevent it. I guess the president advised himself, or other people advised the president not to carry out the directive of the prime minister. And we know how that ended. It ended with the president's action subject to a court review, and the president was shown to have acted improperly. That is what they're inviting President Kangaloo to do. Because I could tell you, I know for a fact that my signature as Prime Minister is on that document with a covering letter asking the President to do what the Constitution says should be done. Who are they to tell the President that she must break the law to please them? To please them. This country is not a banana republic. It is a country that is run under a written constitution. And it is just outright wrong for parliamentarians to so mislead the country on a regular basis. Even going as far as to lie, to say that this is the first time the Prime Minister is appointing Silk, and obviously there's something funny about this time. When any check, and they are lawyers, they should know. I'm so glad I'm a geologist. And of course, let me tell you a story, and it's not a Nancy story. And let me tell you where I came from on this matter. I was opposition leader when one of my members came to me to tell me that she was being offered silk. This was after the he say, she say, give me my silk. Self-appointed silk took place. The next year, or somewhere around that time, I think it was 2014 into 2015, somewhere around there, my member come to tell me that she's going to take silk because it has been determined by the government then that silk ought to be the entitlement of leaders in the parliament. So if you were, as that gentleman was, leader of government business, and as my member was leader, opposition chief whip, that guaranteed and required that they take silk. And I told my member, you're not taking silk, you're not taking khaki, you're not taking crocus bag, because that is not how it ought to be done. And I forbade my member from accepting that silk. Today I see that same voice getting up and accusing the country's president of nepotism and making all kinds of aspersions against the President of the Republic. And I'm simply objecting to the hypocrisy of the UNC. I read the papers today, and let me quote for you what the former Prime Minister had to say. Opposition leader, I'm reading here from the Express, page 5. Opposition leader Kamla Prasad Bisesa has questioned whether the President's husband and brother, who are now conferred with senior counsel status, will continue to get millions of dollars in state's brief. 2 questions I have there. One, am I to find some way to dictate to the legal profession, the government, the president, in my oath that says no malice, no ill will, no fear, no favor, that somehow, because these gentlemen or ladies have now been conferred with the title of senior counsel as part of the operations of the court and officers of the court, that they should not get state brief. That's what she's saying. And then she goes on to say that the state briefs is something that brings millions of dollars. No. If that interpretation is correct by her, is that the reason why she took silk when she was Prime Minister? Recommending herself to the president? And if that is so, did she declare this value of the silk to the Integrity Commission, which says that you have to take no action which gives you a benefit as a result of the job that you hold? Does she want to continue those discussions in public by the national community? Millions are going to flow your way now because you're senior counsel. Is that why she and her attorney general grabbed those titles when they were in office? And I want you to go back and read what I said there a while ago about who should qualify for SYNC. And tell me if the then Prime Minister fits those categories. And then has the gall to come now and create mayhem and manima in the country over other people who under the best process available. Because I take my job seriously. I'm not here for fun. I'm not here for fiction. Because these are the country's records. And I will not allow the government to be presented in that way. And the office of state will not be presented to our children like that on the whims and fancies of people who don't know anything about the truth and will continuously on a weekly, daily basis misrepresent the administration's actions in this country. I simply want to congratulate all the people who today in Trinidad and Tobago can quite properly be called senior counsel, because I know they have the acclamation and acceptance of the vast majority of their peers. Can't hope for more than that. And finally, I want to say that the WHO has now indicated, thankfully, mercifully, we are in a position to say so, that COVID is no longer what it was. On the 5th of May, which is a few days ago, the Director General, who is familiar with us, familiar to us, the DG of the WHO Health Organization, the WHO, determined that COVID-19 no longer constitutes a public health emergency or international concern, PHEIC as it's called. However, this does not mean that the virus is no longer in circulation and cannot still pose a threat. In other words, the virus of COVID-19 has taken the status of other infections, other infecting agents that we might know about, which are circulating, and if you get infected with them, they can threaten your life. That's where COVID is now. But it is no longer of the scale and of the virulence to be an international health emergency. The virus has to stay, so countries need to transition into long-term management of its effects and its presence. That being so, in Trinidad and Tobago, we have already removed most of our responses in consultation with the CMO and the Minister of Health. And in before the end of the week, the Minister of Health and the Attorney General will take steps to remove the restrictions which are in place to stay. Initially, they were put there to be there in force until July. We are now going to discontinue virtually all of those and the requirements for COVID testing to travel and to enter the country and things like that. The only thing that we think we will keep is in the health system where it is prudent to keep masks on so as to protect patients and employees. That appears to be the only area. But let us wait until about Friday into the weekend when the AG will have the opportunity to redo the legislation, the regulations, and they will come to me and I will sign off on that. And the Ministry of Health, guided by the CMO, we will determine what little vestige we keep, but we have to tell ourselves, COVID has not gone. It has receded considerably, and we will live with it as the rest of the world is at the point in time. But do not be surprised if from time to time you hear people have COVID and they are responding badly, because a small percentage of people may respond badly to the virus when they get it. And in those cases, if you are positive for COVID, even inside of your family, I think I would not be surprised if we still, common sense require that if you have COVID, don't expose your, that aspect of the COVID management, where if you have COVID, you try not to expose yourself or to expose your elderly family members or young children and so on. You have to manage that. And the best way to manage that, if you know you have COVID, is isolation. So that's so it's pretty much on its way out. Let's hope that it keeps going in that direction and become part of our historical and health record. Thank you very much. If you have any questions, I'll take a few of them now.
Chancellor Van Newsday. I have a few questions. I'll start off on the issue of the...
Let me see. It's 4 o'clock. We'll take questions until 4:30. I'll give you half an hour, but don't take a few. I'll take 2, and if we get a chance, we come back to you later because your colleagues, I'm sure they will have some questions.
I'll start off on the issue of the awarding of silk. Wouldn't you agree that the optics of the president's husband and brother being awarded silk at this time, with the backdrop of the president of the Criminal Bar Association seeking to have some sort of clarification on this entire process, still pending?
I draw your attention to my requirement to do my job. And the fact that any person, whether it's criminal, bar or bar criminal, whatever it is, has a requirement for clarification does not impact on the duty I have to the wider public. And I've said to you before, in very clear English, that familial connections played no part and the president had no say in not carrying out the directions of the cabinet. So that is not a matter that is, open. The fact that some persons wanted it delayed, we could take that discussion further, There are very prominent people in this country who don't think that I should be prime minister or that they should be a prime minister at all. They believe that there should be an executive president. They believe that the cabinet should not be appointed by the prime minister. It has too much power for one man. They believe that ministers should come from the non-political arena. All of these are beliefs and concerns, and if they go and file a suit, what we'll do, stop the government until the law settles that? No, we don't do that. If the law changes for whatever reason, then I have to comply with the law. In the meantime, I can only act within the existing law, and I'm not constrained within the requirement of the existing law. So those kinds of interpretations might make some people feel that they're carrying the national discourse. All they're doing is muddying the water, especially when they themselves can show you their record, how they handled it when they were in office. I'm telling you here about a prime minister who appointed herself, silk, and we probably use other people's appointment to cover that. But the bottom line is that is there on record. And that was a great opportunity to do what you're asking me to do now. You didn't do that then?
I'm sure the question was asked then as well.
And the fact that you was argued then, what was the argument? What was the argument? That the prime minister should not, I have not given myself silk. Because, lawyers come in various categories. My grandfather has a serious number of categories of lawyer. Bush lawyer, fireside lawyer, and good lawyer like Bunzi Bruno. Right? So, I did not take silk. The bottom line is, the taking of silk by a lawyer who was in office. Right? That's our record. And I will tell you, when it's all said and done, what has been done on this occasion, in terms of process, in terms of transparency, in terms of function, would be among the best. Because I take my job seriously.
So all that we are hearing now, this is not the first time something like this would have been raised. In 2018, it was raised as well. And
what was raised?
The issue of awarding of silk and the due process, and how that was.
What was raised about it?
Forgive me. That politicians should be removed from the process entirely.
Who said that?
I can't recall who, but it was raised.
That don't mean I have to agree with it. The fact that it was raised by somebody doesn't mean I have to agree with it. Because you see, we fashion ourselves and say we have a Westminster democracy, and we wouldn't leave the Privy Council unless the nipple dries up in our mouth. Who appoints the law lords in England? Who appoints the law lords in England? It is the Prime Minister. When President Kennedy won the election and he had to appoint an Attorney General, who did he appoint? John Kennedy appointed Robert Kennedy, his brother, as Attorney General. And if we know anything about history, he was appointed not because he was the president's brother. It was because he was an outstanding lawyer, and the situation at the time required someone of that competence and with his standing on the matters. And that is why, on the night when Martin Luther King was assassinated, historians will tell you that the speech that Robert Kennedy, the brother of the president, made in that situation went a very long way in preventing a racial conflagration in America. Not because he was the president's brother, it was because he was professionally in the profession of politics and law at that moment, the man for the moment. I did not consider whoever you have objections to because of the familial contact. You know why? Because I was under oath to not act out of fear of what you and others will say about their family. As a matter of fact, there are very many families in this country where large numbers of people have risen to the top in professions and other services. And I think it is to be commended. And there's a great distinction between nepotism, which we know what that is, because if the face of nepotism is known, we know who to look at. And of course, having members of your family who can do great public service on the strength of their own backbone and professional integrity. And on this occasion, every person who I've had reason to consider and honor to recommend to the president, I think every one of them earned that position on their own without reference to their family.
Who advocated that no member of the executive should be involved in the process of selecting people for Silk?
Since when?
Jensen had raised the fact that that position had been taken. And the Attorney General is here. I don't know if he can correct me if I'm wrong, but it is being said by the critics of the government that the Attorney General had espoused that view in 2015 as president of the Law Association.
Yeah, but the Attorney General did not select those 18 people. I did. There's no way in the law that says the Attorney General select people for Silk. I consulted him. He consulted the Chief Justice. I got the outcome of that consultation. I discussed with a lot of people. But nowhere in the law does it say the Attorney General is appointing Silk. So if there were efforts being made to have him appoint them, I know they wasted their time.
In the position that there should be an independent.
Everybody's opinion has value. Everybody's opinion has value. I just told you a while ago, there are people whose opinion is that I should not be the Prime Minister, or we should not have a Prime Minister, or that we should have an executive president, or that we should not have this. So everybody who has an opinion, that opinion is valid and valuable. However, where it falls for decisions to be made, those decisions are going to be made under what the law permits, if they're going to be lawful decisions, and what the circumstances require at the time that they're made. Right? Because I give you an example. Suppose we take the position that somebody go and file a suit or query in the court saying that the executive ought not to be appointed by one man. What do? Not have a cabinet when the law says there must be one, and wait until this matter is teased out in the court and comes to its logical conclusion at the Privy Council sometime? No. There's a place for opinion, there's a place for fact and action, and there's a place for evolution. I have no doubt that maybe sometime in the future there might be an evolution to a different point. I am not in control of that. But now, where I have a duty to act, because the circumstances warrant it, and the authority is not there, and my duty is to do it, I hear you, but I proceed.
How would you respond to the position that the timing of the awarding of silk to the president's brother and her spouse?
As I said, there's no link, regardless of who. I could well imagine. Suppose after this, after I signed off on this, suppose I had given that to, as a matter of fact, you know, it could have happened like that. Suppose there was somebody acting as president, that Tobagonian. Our president should have gone to the coronation, and it could easily, I'm not realizing that, it could easily have happened that when I send that for presidential action, there could have been an acting president there who was a Tobagonian. You know what the argument would have been today? That I waited until the president leave the country to get the Tobago acting president to do it. And that would, I mean, no water would have washed that away. It only now dawned on me that that's what could have happened. It's only because the president has, unfortunately, she damaged her leg, though she wasn't away. That would have been a story that you would have told.
The thing is, the president...
And there was no way that you were not going to jump and probably believe that. And I could tell you, it has nothing to do with that, who is at President House. Because it doesn't matter who is there. The Constitution says the process of selection ends with the Prime Minister's selection. And the Constitution says once you receive it at the President's office, there's no legal room to say no or to review it or to amend it. That's the Constitution. I'm sure there are those who say that that's a bad Constitution, but that's the one we're working with until it is changed.
Prime Minister Karen Jose-Philip from TDT, but didn't you think the president was sworn in on March 20th and we are now at May 8th? As Ria said, maybe the timing, the public perception, the president's husband, the president's brother getting silk, even maybe some of your PNM supporters would be disappointed or would be outraged.
I don't think so at all. I mean, what is the time? 1 week after? 6 months? A year? Could I tell you, if it came a year, 2 years after, some of these obscurantists would have said, is somebody brother, is somebody husband. That's what they do. Right? This is something that I have not just gotten up one morning and do, you know. The Attorney General will tell you that. I didn't just get up one morning and say, okay, let's go and appoint silk. These things come after a thought process of a period of time, and you get to a point to do it. When I gave the clearance to proceed with it and to bring it to me, it was then, it's done now, I move on to something else. Yes.
Just to round you from CNC3, you would have mentioned several times that everyone's decision mattered, right? The Law Association have issued a statement this morning saying that, you know, they would have issued a call for a consultation with you on the establishment of an independent committee to review the selection process, invitation that you did not accept. Is this something that you will consider going forward, meeting with the Law Association and bodies to discuss the matter?
I have no, if I think it's necessary, I would. If I think it ought to be avoided, I will. And what I would not do is take the Law Association's position as gospel. The Law Association of Trinidad and Tobago has a lot of work to do. Right? And I'll advise them to distinguish themselves in the process. But in terms of the Law Association has written, I have taken a position on it, and I do not think that my position is surprising, but maybe tomorrow I might have a different position.
Prime Minister, good afternoon to you, Urbashik on TV6. Given what had happened, you know, as you mentioned, the former Prime Minister recommending himself for the conferring of senior counsel status, and even the speculation which is live today, Do you think that there's need now, or there's reason now that we relook this process to include, some of the same things they said about the procurement legislation, like the ineligibility criteria, challenge proceedings if someone thinks that they may have, and also like an evaluation committee?
That is procurement, and of course that's why you have a parliament. A parliament deals with all matters of public interest that may arise, which require discussion, evolution of thought process, maybe presentation of a bill to the parliament, and so on. So we do have provisions for that, What we don't have is, enough room for those who think that it's just mischief we are about every day. There are procedures for this. And if the appropriate procedures are entered into, then there's nothing to, look, not too long ago, how long ago it was? A few years ago, we did a comprehensive overhaul of the parliamentary procedures, government and opposition. We looked at changes, look at the budget debate now is a whole month with so many days of examination and line by line. These are things that took place where they're supposed to take place. And if there are people who have issues that require the attention of the parliament, then the parliament will pay attention to it, among other things that are already there. So I'm not saying that there's no room for adjustment or for receiving other points of views, but there are processes and there's timing.
Yes, sir. So
But we started on procurement just now. We could go back to say, just I'm not finished it, because later, so much of the state's largesse comes from, so much of the largesse goes through legal routes. And you just talked about some of the issues involved with monies going to particular attorneys general and so on. Do you think then that even that professional body outside of the procurement framework, that it really leaves open the continuation of an area of possible corruption?
No, I think that's where I think you're wrong. I did not leave anybody out. As a matter of fact, to the best of my knowledge, the Attorney General of Trinidad and Tobago, in assisting the Prime Minister in distilling this matter, he was in contact with the Law Association. That is to the best of my knowledge. The process under law gives certain breadth of involvement of some people, and it is on that basis why the Attorney General, who was on assignment, sought to make contact with the Law Association so that their inputs could be had. And that is as far as I will go as the geologist who run Trinidad and Tobago.
Prime Minister, I trust your memory. When did this process of awarding silk begin?
Okay. Yes, sir, Vashi.
Mr. Prime Minister, you would have just returned from your trip to Barbados. I was kind of curious, Barbados is like 1/10 the size of Trinidad. Did you have a chance meeting with the Prime Minister across there? Any discussions whatsoever?
I spent the weekend in Barbados. So I have a very good relationship with the Prime Minister if I'm in her country for. As a matter of fact, when she was here for the symposium, that's when she knew I was coming. So she even put some things in place for me. But that's nothing unusual. I mean, that's quite normal.
Indicated her intention to also write to Prime Minister Motley seeking some answers as it relates to the Brent Thomas matter, the involvement of the Asian police and authorities.
We will discuss that.
I have no, that's a matter for the opposition leader and for the Prime Minister of Barbados. I have no thoughts on that, and it matters not to me. If the opposition leader wants to talk to the Prime Minister of a Caribbean country, she's free to do so.
Did that come up in your discussions over the weekend?
Honorable mentioned that there were our departments were looking at it, because my understanding is she's in the same position I'm in, and we'll await, what our departments come up with. Contrary to what you're being told in Trinidad and Tobago, that X knows Y and A knows B. I'm sure that somewhere along the way we'll find out what really went on, and if there are issues to be dealt with, as I said here earlier on to you, the media, if there are operational issues to be dealt with, we deal with it. But it's an evolving situation, and we'll see what comes up.
Was there a concern that the international bodies, like for instance, Wade Mark said the opposition is also intent on writing to the UN and several other international organizations? Did that come up that the Caribbean can be put into a negative light?
I think that is the intention. I spoke on this matter before. At the last press conference I had last Thursday, I spoke at length on this matter, and I think you're right. That is the intention, that we be perceived in a certain way, even though if one takes the patience to examine the facts, we will not be so slandered. But there are individuals who think that their pronouncements will slander us. I heard Senator Jolene John saying that Trinidad and Tobago doesn't have a government. What we have is a rogue terrorist organization. No. Any citizen who thinks that, I simply ask them to compare us with others. If you know, there are so many countries in the world where their citizens want to be in Trinidad and Tobago, that description will shock them. Because that is a description of a local parliamentarian, which in fact bears no relation to what Trinidad and Tobago is. One of the freest societies, with government accountability, media, and so on. I mean, we're having safety and security issues. Nobody's saying no to that. But I mean, we're not the only one. There are lots of other countries having that kind of problem, and we are fighting it either alone or together. But patriotism comes hard to some people. Bad talking the country comes easy. Staining our image in the international community. I distinctly recall very early in proceedings when I spoke about not damaging the country's image, that one member from the opposing side said, what image are we talking about? We have no image to defend. I don't agree with that. Trinidad and Tobago is a proud little country in the Caribbean. We have our problems, our challenges, but I am so proud to be a citizen of Trinidad and Tobago.
As it relates to our problems, crime seems to be maybe at the top of the list. If we look at murders as a litmus, some may argue that we are experiencing unparalleled levels of violence and violent crime. Has the formula failed? Has our formula failed?
Of course, some things are failing. We have to find out what is failing, where the failure is taking place, because certainly what is happening now cannot be accepted as the norm and cannot be allowed to continue indefinitely. I can tell you, I meet with the National Security Council regularly. I meet with heads of the security systems. I'm in touch with what they're doing and how they're doing it. We're not getting the kinds of results that will put an end to the trend. But, one can take comfort in the fact that we do get some results. And if you ask yourself, had the police and the support systems not been extracting the arms and ammunition that they have been from time to time, and the few persons that what really would have been the story? But we are, in fact, having some serious concerns. I myself have serious concerns. I continue to have them. And I would have been able to say more to the country, but I can't say more now because I'm constrained. But the time is going to come when more will be known, and then you'll understand the vantage point from which my concerns run.
The National Security Minister, Minister I.A.N, has been accused of misstepping and misspeaking. He's been the subject of condemnation by the judiciary for a particular statement. Have you spoken to him at all about this?
I speak to my ministers all the time, and I have not taken a public position on this matter because there's a limit to what one can interpret. Interpretations are very subjective, and personal feelings are very personal. So I can't say no more on that.
How did you interpret the statement, Prime Minister? Yeah.
I saw what was said. I understand what was said. So there wasn't anything for me to interpret. I understood what was being said.
What did you understand by that?
Thank you all very much. I'll see you again soon. Next time.